Hey everyone, it's Rob Ryder. Today, easier to get forgiveness than permission because we're going to make substance trump form. At least that's the intention. And my last video was about the Inspector General and their need to first be correct, then take action, which is good for the Inspector General. He's got the army behind him. We don't. Well, not yet. And so, we just have to give them probable cause by whatever form we can to trump the fact that we didn't fill the paperwork out right. So, whatever you need to do to get it to them, to serve them, right? Serve the paper. Because until you serve the paper, you really haven't done anything. I don't care how much time you put into it or thought about it or how many meetings you had and how many people's opinions you got. Until you actually submit it to somebody, you haven't done anything. And that's really what you want to do is, at least for me, I want to submit paperwork to them to make them have to respond if I can to see what they say. And so it's just a philosophy, right? That's how I like to do mine. And so for me, easier to get forgiveness than permission. That's just the way it is. That's my life. And I am Rob Ryder. My email address is courtofrecord@aol.com. Phone number 616-712-6179. That'd be in Michigan. Eastern Standard Time, I believe. Today, it's Monday, January 9th, 2017, and I ask that if you can, please donate. And if you can't, well, don't worry about it. I'm not in it for the money, but I do have to pay my bills, and I got this really nice new computer, but it wouldn't let me take my Word 2000 from my 14-year-old computer and upload it. I wonder why. Jeepers, they're forcing me to buy new software after 14 years. I'm going to help them out. So you could send it by PayPal, and the account is my daughter's email address. So that is the account, ashleyrytleski@gmail.com, ASHLEYRYTLEWSKI@gmail.com. And I had forgot, but I shouldn't have. You could go to Walmart or Myers, which is Western Union, Greenville, Michigan, 48838, and send it that way. Somehow they would let me know. I've had it happen in the past. Or there's always the mail. Robert Rytleski, living man, fast the substance, 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341. Okay, so what? I had done a video just the other day, and I talked about the AR 20-1, Army Regulation 20-1, that the Inspector General follows, and they have this thing called asking for request. I should go get it. Hang on just a second here. It was this thing right here that I put in, the Inspector General action request. And okay, how come you won't disappear? Okay, there we go. And so, and I just put this in between Christmas and New Year's. And about the day I put it in or something, I got an email from a lady down in Ohio. Her name was Sandy, who was going through a foreclosure. And she had to put an answer into court by January 9th. And at the time I thought, well, we'll just do something like this and send it to the Inspector General. But after I thought about it, I said, okay, well, let's just do what they said, and we'll submit something to the court first. That if they don't do something, we'll tell them we're going to take them to the Inspector General and see if we get the court to do it. And that's really what this video is kind of about, is what we did there. So once I find the right file again. You don't need to watch on this. Right back. Okay, well, let's start here. So if you went to Google or whatever, put in Stark County, Ohio Courts, you would find this thing about online case docket. And you click on it, and it looks like this. And if you clicked on Common Pleas, just make it easy, do all, hit Continue, you would come to this page. Now, because I've done this before, if you put in 2016 Charlie Victor 01508, that's 2016 CV, Charlie Victor, 01508. And search. Well, you'd be looking at things that have to do with this court case. Now, I went too far too fast because I want to point out. And if you read this little disclaimer, which I know is very hard to read there, so I have it somewhere else, if I'm not mistaken. Where are you? Disclaimer. Very interesting what it said. Disclaimer, the public record information viewed here reflects the docket entries in journals required by Ohio law to be kept by the Stark County Clerk of Common Pleas Court. This information reflects the actual documents filed, which are considered public record and contained in the official case file records held in the, and this is the important part, Clerk of the Court's Legal Division office, located at 115 Central Plaza North, Canton, Ohio, 44702. The data entry can generally be deemed reliable, however, cannot be guaranteed, and no event shall Stark County Clerk of Common Pleas Court be held liable for damages of any nature, direct or indirect, arising from the use of this Internet product, including loss of profits, loss of savings, or other incidentals and consequential damages. So, the Clerk of the Court's Legal Division office isn't necessarily the Clerk of the Court's Counter-Troll Division office. You know, the people that march up and down the counter all day. You would have to ask specifically. I would copy this, give it to the clerk, and say, I want to know where this Clerk of the Court's Legal Division is. Because that's where all the files are for everything. And, in fact, what was that one we just did earlier? I should have had that one right. Gee. Come on. Still trying to get used to this computer. Clerk of the Court's Legal Division. Right. Google on Clerk of the Court's Legal Division, and you will find Belmont County Clerk of the Court. And it says the Legal Division of the Belmont County Clerk of the Court serves and supports the Court of Common Pleas. This division is responsible for maintaining and providing public access to the permanent court records for the following dockets: civil, criminal, court of appeals, domestic relations, domestic violence, civil protection, withholding tax, sales tax, and judgment docket liens. That's where all the liens are. It's in this office. What office? The Legal Division, Clerk of the Court's Legal Division office. That could end up being real huge. And so I'm just going to point it out, right? That was the disclaimer, and that's just a freebie. It wasn't even why we were here. But we're moving on now. But where do you find this? You're going to find it right there at the entrance, where it says disclaimer. Okay, continuing on, and then we're going to go in, boom. And then over here is, these are all the same case number. I know it's kind of small, but take my word for it. You can click on any of them, take your pick, and you come into this online case docket, and you got a summary, docket, parties, receipts, service, close window. Well, you hit docket. And there on 1/4/2017, it says Defendant Sandra Schultz, response to plaintiff's motion for summary judgment / request for relief with proof of service. Well, that's how we responded to their order. And I'll show you what the substance was, but it won't look anything like the form I gave you that as it was put in, because Sandra didn't have a computer. She had to do it off a Kindle or something like that, and so it doesn't look anything like it. But they still took it because of the substance, I believe, and well, we'll find out. So let's go take a look at a few things here. So what did we have going on? what was what? So the first thing that happened was, what did she send me? God, I got so many freaking forms anymore. Open with. Okay, so let's just start from the beginning, right? This is what first, well, one of the first documents that she sent me that when I read it, I said, oh, I think I know what we'll do. And this was filed on December 27, 2016 in the Stark County, Ohio Clerk of Courts. So I believe that's the right office, but I don't know. But what I do know is that the name of the court isn't in the Court of Common Pleas, Stark County, Ohio. It's Court of Common Pleas, Stark County, Ohio. As we'll see when we look at the civil procedures, it shows in the Ohio civil procedures what the caption should look like in a court case. Between Nation Star Mortgage LLC and Sandra Schultz. On December 22nd, 2016, plaintiff, that'd be Nation Star Mortgage, comma, LLC. That comma shouldn't be there if they were proper corporation that's spoke about in law. We'll leave that for later. Plaintiff filed a motion for summary judgment. The defendant shall file a response to the motion on or before January 9th, 2017. So they didn't say an answer, they just said a response. Well, then I said, okay, well, I got a response for him. The plaintiff shall file a reply to the defendant's response on or before January 19th, 2017. So on the 4th of January, the response went in. The court recognized it. And now we're at the point of waiting to see what the defendant does. Then based on that, non-jury trial date remains scheduled for February 6th. So at that point, it will be trial, non-jury, which means the judge will make the decision, and he's going to have all the facts. If the judgment is rendered prior to trial date, the trial date will be automatically canceled. Oh, we may not have to wait till the 6th. They could just do it sooner. And so forth and so on. And, by some judge using the middle initial instead of her proper name. She could only do that if she's in the military, because you can serve in the military under an assumed name. But that isn't the name, right? If you had to be an attorney at law to be a judge, that's not the name that this judge became an attorney with. They would have used their full middle name. They used your full legal name. Okay, so enough on that. So that was that. And so what we answered with to that was, I think it's this one, Court of Common Pleas, Stark County, Ohio. As we'll see again in the procedures, that's the way that the courts, that is the name of the court. First thing it asks for on the summons or the complaint or whatever the first form is the name of the court. And it isn't in the, there is no court in the. That would be a fictitious name for a court. And so we used the addresses that were on some earlier paperwork, because we were looking at an order just a minute ago that had been put in by the court, and they didn't put the addresses, right? The judge didn't really do it the way that the law says to do it. I just believe you have to put the addresses. You have to do the caption the same in every document. What the heck? Put them in. None of that matters. Response to plaintiff's motion for summary judgment, right? That's what we had to do, and request for relief. Case 2016 CV 01508 is a violation of civil liberties protected by the Bill of Rights. Well, just state your claim. Let's get it over with. I, Sandra Kathy Schultz, that is her middle name, sui juris, in her real person, real party and interest, to rights, titles, and interest of property whose ownership is contested in proceedings under Case 2016 CV 01508, informs Ohio's Court of Common Pleas that I claim these proceedings are a simulated legal process under color of law, violating my civil liberties protected by the Constitution of the United States Bill of Rights, for which I demand relief. Number one, plaintiff, Nation Star Mortgage, LLC, has no legal standing in Ohio. Number two, attorneys for plaintiff Manley, Dees, Kalaski, PLLC have no legal standing in Ohio. Attorneys at law claiming to represent plaintiff use a pseudonym to conceal their full legal name, which was licensed to practice law in Ohio, are engaging in official misconduct and are in contempt of the Supreme Court. Defendant is a legal fiction, not a real party in interest to any real or personal property. The national color flying in the courtroom is a symbol of a military court, not a court created under the Ohio Constitution to adjudicate domestic law. And that's the problem with this free program that I have to use, because I can't use Word, is anytime you try to save something, it doesn't want to save it quite right. And you can't open it in Word, and if you try to make a PDF, that's what happens here. If you try to make a PDF out of it, it will shift your stuff over. I'm not complaining, I'm just saying, even I can see that's wrong. So I, Sandra Kathy Schultz, sui juris, ask for relief by a declaratory judgment that acknowledges my undivided interest in the legal and equitable titles of all property in dispute in this matter. I ask the court to see to its prompt return, along with any unjust gains, correction of official records to indicate the same, or other remedy the court deems just. And the court deemed that the defendant's response to plaintiff's motion for summary judgment / request for relief with proof of service. So now the court has both sides of the story. The one side says it's theirs, and we're going to say no, it's ours. Well, Sandy's going to say it's hers. And it's really just that simple. Right? The plaintiff, Nation Star Mortgage LLC, they don't have standing in Ohio. And neither does Manley, Dees, and Kachalski, PLLC. They don't have legal standing. And you just go look them up online and you'll find out they don't exist. But even if they do or think they do, well, then they can bring in their certificates of good standing. That's the proof you ask for. And we didn't ask for it here, but, that's what they'd have to prove it with. I'm saying they don't have it. Well, show me your certificate of good standing. And the attorneys aren't using their proper full legal name. They're using a pseudonym, middle initial. The defendant, right, it's not Sandy in her full legal name. It's not Sandy Kathy Schultz. It's Sandy Schultz or Sandy K. Schultz, a.k.a. Well, that's not a legal fiction. It's not her. And it has, they don't have, the legal fiction is not a real party in interest to the property. Sandy Kathy Schultz is, because it's all tied to her Social Security account. And finally, the national color flying in the courtroom, that is a symbol of a military court. That's a military flag. It's an Army flag. It's not a Navy flag. It's not Admiralty. It's an Army flag. It's a military tribunal. And so it's not a court created under the Ohio Constitution, which would be the Court of Common Pleas, right? That's what was created under the Constitution of Ohio to adjudicate domestic law. Those are all true things. And then because, we didn't write much, we had room to put the service on the same piece of paper. So one piece of paper. Now, when Sandy went down there, she didn't have a computer that would print it out like this. And so she had to print it out on however she did it. And so it's really just kind of written right down the middle like paragraphs, right? And it was on more than one piece of paper. And even though the clerk didn't want to take it, well, they ended up taking it. Now, that could be because Sandy just, stayed there and said, no, you're taking it. I don't have time for this. I don't know how it was, but it's a matter of, asking forgiveness. Instead of getting permission, just go there and put it in. It doesn't matter what it looks like. Go there and give it to them. And good for her. She got it in. And so we're going to see what happens with it. Okay, so give me just a second here. Okay, because this is a little bit easier to show here. All right, this is the grammar stuff. I mean, everybody's, talking about the way they do that things are written, and it all does mean something. And here, this would be an example, although I really couldn't tell you what it is. But if we look, it says response to plaintiff's motion for summary judgment. Request for relief with proof of service. All written together. But any place else they talk about proof of service, which isn't on every line, like this one here, doesn't talk about any kind of service, but that was an order, right? So I guess it wouldn't have to be. Plaintiff Nation Star Mortgage LLC motion for summary judgment, motion for default judgment, and to dismiss defendant, hyphen, with proof of service filed. Well, what is with proof of service filed compared to with proof of service? Right, because this one doesn't say any place where there's been anything filed. That's what I'm saying, this first one. However, it is on the docket that has the disclaimer that says this is in the official record of the Court of Common Pleas in the Clerk of Courts Legal Division. So there you go, right? I mean, all sorts of little things. And then I had mentioned certificates of standing, so I don't want to forget to. So this is what it says in Ohio. If you were just to Google certificates of a standing, attorney certificates of good standing, you could probably find this quite easily. The Supreme Court Office of Attorney Services issues certificates of good standing. To request a certificate of good standing, please complete and submit a request form. Now, this isn't you. This is for the attorney to do. Most requests for a certificate of good standing will be processed within 4 business days of receipt. A request for a certificate of good standing with disciplinary information may take 10 business days. There is no fee for a certificate of good standing. Requests for certificates of good standing shall be or may be emailed to, I guess who should go to. So it's no problem for them to get one, right? And so then if they did, well, you want to see it and see what name's on it. And if they're not using the same name that's on the certificate, like the full middle name, well, then they're not using the name that's on their certificate. But the question is, can they get one? Can they get a certificate of good standing that they're going to give to the Court of Common Pleas, the real Court of Common Pleas, and get them to agree? Because that's what we're trying to get our paperwork is. If there's a real Court of Common Pleas, we're going to put it in there instead of the in the court. And it's the same for business. This is through the Secretary of State. They have a place for a certificate of good standing for a business. So if the plaintiff can do business in Ohio, well, they're going to have a certificate of good standing. If the attorney firm that says they're representing the plaintiff can do business in Ohio, well, they're going to have a certificate of good standing. And the attorneys for the attorney firm to be attorneys to practice law in Ohio, well, they have to have a certificate of good standing. You don't have to do a thing until they prove who they are, except to say, I need them to prove who they are, or it's a violation of my civil liberties because it's denial of due process. Maybe under Article 5 of the Bill of Rights. And the fact that they're using your middle initial name or your name backwards or some other thing, well, that is, you are not secure in your persons or person, papers or effects. And that's a denial of your civil liberties, and the military has a duty to enforce those. And I believe because there's military flags flying in these courtrooms that they're military courts. Let me show you something. Okay, so part of the video, mainly the video I did last time, was showing that, hey, we're under the laws of war right now, whether we believe it or not. We're under martial law. It was never rescinded after the Civil War. And if that's the case, well, then this field manual is in effect today, the law of land warfare. And I went through some of this in the video, and I just, I didn't go quite far enough. I wanted to show one other thing that I hadn't. However, because I can now, I'm going to show these things. So this is the, basically, if you read this, it says the military is going to have to follow lawmaking treaties, right? That's what they're going to follow. Treaties to which the United States is a party. Hague Convention, Hague Convention, Hague Convention, Hague Convention, Hague Convention, Geneva Convention, Geneva Convention, and then this thing called the Treaty of Treaty on the Protection of Artistic and Scientific Institutions and Historical Monuments of 15 April. It should be 1935, not 85. However, only the United States and a number of American republics are parties to this treaty. And because America is, well, then they have to follow it. And this is in effect during times of peace and times of war. And all cultural institutions have to be protected. Now, they're supposed to have been put on a list if you go and read the actual act. And so Rosita's already asked him. She's already fired out a letter to the, well, I'll do that in my next video, hopefully. We're going to find out, hey, where's this list at, right? If it's on the list and you're a member, well, then you're protected. But it says cultural institutions, and cultural institutions include churches. So if you're a member of a church, you should be protected. Your proof of being a member of a church, at least as a Christian, is to have a freaking baptismal certificate. That made you a member of the church. Right? You're in the body of Christ. Okay. But a little further down. So this is what I wanted to show. Military government and martial law distinguished. In the practice of the United States, military government is the form of administration which may be established and maintained for government of areas of the following types that have been subjected to military occupation. D. Domestic territory, recovered from rebels treated as belligerents. There you go, right? So it can be in your own backyard. Although military government is an accepted concept in the laws of the United States, the limits placed upon its exercise are prescribed by international law of belligerent occupation. International law of belligerent occupation. Whatever that is, that's what, if we're under military government, that's what the United States is going to follow. The military. Other countries exercise jurisdiction in occupied areas through types of administration analogous to military government, even though they may be designated by other names. In the United States, martial law is the temporary government of a civil population of domestic territory through the military forces without the authority of written law as necessity may require. Right? There's no written law that says they have to tell you that you're under martial law. And if you are, you are. But they did make a law that once martial law, and this is in the Labor Code, it's the second article, right? Once martial law has been declared, only by proclamation or a peace treaty can it be rescinded. And if you can't prove that since the Civil War, then we're still under martial law. The most prominent distinction between military government and the term is used here in the martial law is that the former is generally exercised in the territory of, or territory formerly occupied, a hostile belligerent, and is subject to the restraints imposed by international law of belligerent occupation, while the latter is invoked only in domestic territory, the local government and inhabitants of which are not treated or recognized as belligerents, and is governed solely by the domestic laws of the United States. Well, that's what we would be under. We would be under martial law, not military government. And if we're not under if we're under martial law, then it's only in domestic territory, the local government and inhabitants of which are not treated or recognized as belligerents. So get that out of your head. You're not the belligerent. You're the peaceful inhabitant. The Army's your friend. Go take your complaint to the Army. And is governed solely by domestic law of the United States. And all I'm saying is that the chief judge sitting in that office as the administrator of the court is like the inspector general's representative in the county. That's what I'm hoping. Okay, hang on a second again. Okay, so we're back to Sandy's case. Here's her note. See these bullet holes here, this exhibit? I believe that this is actually entered into her court case, which I believe is what they would have to do, because the proper thing, well, let's just look at the note first. Okay, so here's the note. 3-page note, blah, blah, blah. We get to the 3rd page. Sandra signed it. Well, they used their middle initial. I think that's interesting, but it's okay. And here we are with the pay to the order of endorsement. That's blank. All right, this pay to the order of was paid to J.P. Morgan Chase Bank N.A. Well, that's who this is. By J.P. Morgan Chase Bank N.A., attorney, in fact, for All American Home Equity Lending, who is the originator or the lender on this particular loan. And so basically went from one bank, home lending, to J.P. Morgan Chase. Now J.P. Morgan Chase has endorsed it again in blank, pay to the order of. And this document, sitting in this particular status, is sitting in the court. So the court now has the legal title to the note. And it's going to determine who this note belongs to, because there's nobody on the pay to the order of line. And we're saying it's ours. Now the reason that the plaintiff could come in with this is because it's in blank. It's treated as a bearer bond, and he who holds the title is the owner. So as long as it's in blank, whoever holds it is the owner, unless they got it by fraud, and you go to a court of equity, right? Because all the court of law cares about is who has it, and what's the rule. The rule says if it's endorsed in blank and you have it, you're the owner. Well, there you go. They could go take it and cash it, but they never do, right? They just leave it this way. We could get it, put our name on there, and go and make them cash it, because it has been converted from your note to a commercial bank note that has the value of itself in dollars within commercial banks, but has no value on the street because it's not considered legal tender. But it's payable on demand, and if you demand payment, then it needs to be paid in legal tender on demand. And you would make your demand by filling out the pay to the order of line. All that to say is this: if this works out right, that's what Sandy will be signing, and the bank or the court will get her a check from J.P. Morgan Chase Bank N.A. Yeah, that's cool stuff. Okay, stop again for a second. Okay, just to point out a couple things that that are probably pretty consistent in everybody's civil procedures. They may use different words, but I don't really think these people. It's a military government. It's all the same, just using different words here and there, and a little bit different style and some local stuff. But at the end of the day, right, whatever the true government isn't changed. And if it's a military tribunal, then it's a military tribunal. And if we had read farther in 27-10, it talks about military tribunals and provost tribunals and all these other tribunals. I just run out of time. And in this, I just wanted to show a few rules. Myself, I should probably start at the very beginning, but I hadn't, because I kind of knew where I was headed when, what we had to do, which is the process, right? Summons. Upon filing of a complaint with the clerk, the clerk shall forthwith issue a summons for service upon each defendant listed in the caption. Upon request of the plaintiff, separate additional summons may be issued at any time against any defendant. The summons shall be signed by the clerk. Right, so these are the things you'd be looking for when somebody serves you, right? It doesn't come from anybody but the clerk. And the summons shall be signed by the clerk. Contain the name and address of the court and the names and addresses of the parties. Be directed to the defendant. State the name and address of the plaintiff's attorney. Yada, yada, yada. So you could just kind of go through and act like this is baking a cake and just start checking off all your ingredients and see if they did it right. If they didn't do it right, well, that's denial of due process. Any one of those things that wasn't done properly, you could complain about as being a denial of due process, which is a violation of your civil liberties. You know, the important thing is you need to state the claim, and the claim is that your civil liberties have been violated, and everything else is evidence of the violation. But the claim is, I claim my civil liberties have been violated. Service by the clerk, right? So then the clerk is the one that's going to do the serving. I think it was number 5 though. I wanted to see that because it was a reference from another line or another document. Jeepers, where are you? Finally. Service and filing of pleadings and other papers subsequent to the original complaint. So let's stop for just a second. So if you wanted to file a complaint, knowing what we know now, into the Court of Common Pleas, then you would go to Stark County Clerk of Court of Common Pleas, Stark County Clerk of the Common Pleas Court, jeepers, to the Clerk of Court's Legal Division. That's where the records are supposed to be. Okay. When required, service when required, except as otherwise provided in these rules, every order required by its terms to be served, every pleading subsequent to the original complaint, unless the court otherwise orders, because of numerous defendants, every paper relating to the discovery. Basically, what? All papers after the original one. This is how you can do it. Serving an attorney. If a party is represented by an attorney, service under this rule must be made on the attorney unless the court orders service on the party. Service in general. A document is served under this rule by handing it to the person, right? That's service. You can hand it to the person. It didn't say you couldn't. No, hand it to the person. Leaving it at the person's office with the clerk or other person in charge. If they have no office at the person's dwelling or usual place, mail it. Deliver it to a commercial carrier service for them to mail it or for them to deliver it. Leaving it with the clerk of the court. Sending it by electronic means to fast mail number or email address provided in accordance with, it's another rule, by the attorney or party to be served. If local court rules authorize, a party may use the court's transmission facilities to make service under Rule 5B2F. The served document shall be accompanied by a completed proof of service which shall state the date and manner of service, specifically identify the division of Civil 5B up above, where we had the choices, by which service was made. Signed in accordance with this rule 11. Documents filed in the court shall not be considered until proof of service is endorsed thereon or separately filed. And that's why what we did is, first of all, it was this form here. So this is in the civil procedures. Towards the end, it gives all these different forms, right? And so this is what the Ohio Civil Procedure says. And it doesn't say in the Court of Common Pleas. It just says Court of Common Pleas and the name of the county. Name of the plaintiff with an address. Name of the defendant with an address. Whatever it is, whatever the number is. The defendant moves the court as follows, blah, 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 which is one way to do it. You get done and you sign it. And then I had on this, now look at all this room that's still here. It's like, well, why would you put it on 2 pieces of paper? Right? Okay, so put the service of copy on the same page as the wording and get it all done at one time. So a copy hereof was served upon XY, attorney for plaintiff, by mailing it to him on whatever date set forth, yada yada, attorney for the defendant. You know, and so those are in parentheses. You can put anything you want. So, you know, as you saw, that Sandy did it sui juris. The form gives various examples of offenses which may be raised, whether the motion should be accompanied by a notice of hearing motion, whether the motion should be accompanied by memorandum, brief, depends on the rules, blah, blah. All papers after the original pleading required to be served upon an opposite party shall have endorsed thereon, when filed with the court, a statement setting forth the date and method of service. See Rule 5, which basically means to put this up there and say that it was mailed. Right? Put it all in one complaint, and that's what we did. Yeah, that's the wrong complaint. Well, here's where she had put sui juris, right? And then just did it again. A copy hereof was served upon. This is the attorney, right? This is who's representing the plaintiff. And if you just look at the words, the way they word things on your documents, you'll see that it's the firm is the attorney, and these people work for the firm. And that got filed. So very, we'll see what they do with it. Okay. Now, because she had sent it to me, just looking at some other documents that came, this was from last year, right? From Nation Star Mortgage. Now remember, it's supposed to be Nation Star Mortgage LLC, but this is Nation Star Mortgage, and they don't appear to have an address. Send a letter to somebody named Sandra K. Schultz, which is a fictitious name or a pseudonym or a legal fiction, but it's certainly not the sui juris personality known as Sandra Kathy Schultz. So they sent it to a fictitious name. Well, that's denial of due process. At this point, having gotten this letter and knowing kind of what I think I know now, you could just write back to whoever these people were, but they didn't give you an address. But maybe you can find it. And just tell them that unless they're going to serve you in your proper name, that you consider it a denial of your civil liberties, and you're going to file a complaint with the military. And you need them to respond to you that that they understand this and that they're not going to pursue the matter any further. Let's see, here it says Nation Star Mortgage, and then here it says Nation Star, not Nation Star Mortgage. Nation Star is a mortgage loan servicer for Nation Star Mortgage LLC. Well, neither of those are these people. You got three different entities. That's just kind of how this thing works, right? And instead of playing their game, just right off the bat, you know, I mean, yeah, oh my God, what am I going to do? Oh, Nation Star is a debt collector. But this isn't Nation Star. This is Nation Star Mortgage. They didn't put an address. So, but what they did do is right here, sent via certified mail. Right? So you could go look that up and you could get the address and who sent it to you. And respond to them and just tell them that you consider this a violation of your civil liberties. And either they're going to respond to you and tell you they're going to cease and desist, or you're going to file a complaint with the Inspector General of the United States Army. Blah, 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 blah. Hey, if that ever works, well then, if you do it to somebody, they'll pay attention. Okay, I think that's really all I had. Other than I'm just one more time to, just to show that we don't have to write a whole bunch. And these details are going to be the same pretty much any time that papers. We're involved in a case. Right now, again, this just came out of civil procedures, how to do the caption, which starts with the name of the court. Well, I had to show that too. Hang on. There's one other form in here. Where's the proper summons? Very first form is this thing called caption and summons, right? So this is the caption right here. And this is the way they want you to do it. So Court of Common Pleas, whatever your county is. AB, whatever the plaintiff, the defendant. So this could be you. You could be the defendant or the plaintiff now if you wanted to be. If you're going to take it to the Court of Common Pleas and not in the Court of Common Pleas. To the following defendants, and it names who they are. You have been named defendants in a complaint filed in the blank county Court of Common Pleas, right? County, blank county courthouse. So this is blank county. So it's like Kent County, not County of Kent. That's, to me, the big thing, because the County of Kent isn't the County of Kent. That form isn't the political subdivision. It's Kent County. That's the political subdivision. So this is the proper substance going on the form. You are hereby summoned and required to serve, blah, blah, blah. I don't really want to read all that. I wanted to get to this right here. Note. The caption above designates the particular paper as a summons. The particular pleading or other paper should contain the appropriate designation, such as complaint, answer, etc. So whatever it is, it's going to use this. It's going to use this form, right? That's the important thing. And so if you're going to do a complaint to the Court of Common Pleas of Franklin County, Ohio, then you would take this off of here and put the word complaint. And you would fill it out as a complaint. This is just the caption. The words will come later, but this is all the caption of the proper way to do the complaint, from which the clerk is going to then serve the people that are listed as the defendants. That's how I read it. So we're not doing a prosecution right now. We've responded, I should say, to Nation Star Mortgage's request. And, well, I have to see what they have to say. But was there anything else on this one? Filing with the court defined. The filing of documents with the court as required by these rules shall be made by filing them with the clerk of court, legal division. That's me adding that part. It doesn't say that, but okay. They didn't say where, but we know they have a legal division now. There's different divisions of the clerk of court. Better find out which one. Except that the judge may permit the documents to be filed with the judge. And that could be why when we sent things to the chief judge directly, they ended up in a court case. Because that's okay to do. Now, that wasn't in Ohio, but it doesn't matter. Right? We sent a letter to the chief judge complaining about what was going on in the court, and the case got dismissed. Or it got closed, not guilty. So now the person's guilty, but they get all their money back and they close the case. You know, whatever their game was to make it go away, they put it into action. A court may provide by local rules adopted pursuant to the rules of superintendents. So I don't know what those are, but that could be interesting reading. Rules of superintendents for the filing of documents by electronic means. If the court adopts such local rules, they may include all of the following. Blah, 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 blah. Okay. I want to look at one last thing, and then we'll call it good. Okay, and just one more time, just to show you that, you don't have to call me to do this or to figure out, well, what am I going to write? My case is a little bit different. They're not any different, please. Just, go find your summons and complaint, put the names down. If you don't have your copy of your summons and complaint, then go get one from the court. Put the names down, right? I'm sure you can find the names, the addresses, the way they did it on something. And just put request for relief. Forget everything else. You don't need to respond to them. You can just put a request for relief. And just say, case, whatever, is a violation of civil liberties protected by the Bill of Rights. Something to that effect. I, whatever your name is, sui juris, in your own person. Real party in interest to rights, titles, and interest of property whose ownership is contested in the proceedings under the case informs the court that I claim these proceedings are simulated legal process under color of law, violating my civil liberties protected by the Constitution of the United States, Bill of Rights, from which I demand relief. Jeepers. You're the only person in your proper name that has any interest, any real party of interest, any of the property. And the property is now in the custody of the court. So if you can get the court to agree with you, they're going to give it to you. They can go and get the liens off your property and give you the freaking fee simple title. Right? You're going to get a complete remedy in equity. Plaintiff Nation Star Mortgage, LLC, has no legal standing. Right? The plaintiff has no legal standing. The attorneys for the plaintiff have no legal standing. The attorneys at law that represent the plaintiff have no legal standing. The defendant is a legal fiction, not a real party of interest to any real or personal property. And the national color, that flag with gold fringe sitting over there in the corner of that court, is a military flag of the United States Army. And therefore, it's a military tribunal. Or at least it's under military control. And if they're not following the law, well, we're going to take it to the military. And I'm just believing, hey, that's what the chief judge is there for. Here you are. The national color flying in the courtroom is a symbol of military court, not a court created under the Ohio Constitution to adjudicate domestic law. Well, why is that important? Well, because they're saying that they're the court of common pleas. They say in the court of common pleas, but they're trying to pretend they're the court of common pleas. Well, not if you're a military court, you're not. And then after you give them 4 or 5 things, then, hey, ask for your relief. Whatever your name is, sui juris, ask for relief by a declaratory judgment that acknowledges my undivided interest in the legal and equitable titles to all property in dispute in this matter. I ask the court to see to its prompt return, along with any unjust gains, correction of official records to indicate the same, or other remedy the court deems just. They may have a better plan. Let them have at it. All right. We're leaving it there. We'll see ya.